Hello friends, welcome to Law and GK. So friends, on this channel we discuss the contents of law and previous year papers of judicial services and other legal exams. And friends, in today's video we are going to discuss the preliminary exam paper of Jharkhand Judicial Services 2008. I hope कि ये videos आपके लिए बड़ी useful रहेंगी. So friends, if you are preparing for judicial services, this channel will be very useful for you. आपके लिए बड़ा ही beneficial रहेगा. And अगर आपको ये वीडियो अच्छी लगी हो तो जरूर लाइक कीजिएगा, शेयर कीजिएगा अपने फ्रेंड्स के साथ. And don't forget to subscribe the channel, and while subscribing don't forget to press the bell icon so that you can get the notification of our upcoming videos. And अगर आपको हमारे efforts अच्छे लगे हो तो in addition to like and subscribe, kindly give us a super thanks. Super thanks is a way to appreciate the content creator. आप जो है जो भी कंटेंट बनाता है उसको अप्रिशिएट करने के लिए आप जितना भी अमाउंट चाहें डोनेट कर सकते हैं. मिनिमम इज 40 रुपीज. सो डोंट फॉरगेट टू गिव अस अ सुपर थैंक्स. सो लेट्स मूव टू द क्वेश्चन पेपर. Question number 1 is, from amongst the choices given, which one of the clause correctly completes the following sentence? I shall have left this place by the time dash. She will come, she would come, she comes, she will have come. She will come. A is the answer. Next is 2. Such words as are similar in sound but different in meaning are called. It is called as homophones. D is the answer. देखिए कुछ वर्ड्स ऐसे होते हैं जो फॉर एग्जाम्पल एक राइट है एक राइट है तो साउंड तो बिल्कुल सेम करेंगे बट स्पेलिंग डिफरेंट है ना, और डिफरेंट मीनिंग है इनके. फिर सिनोनिम्स यू नो, सिमिलर मीनिंग, एंटोनिम, ऑपोजिट्स. होमोनिम्स, व्हाट इज होमोनिम्स? इसमें सेम स्पेलिंग और प्रोनाउंसिएशन. फॉर एग्जाम्पल टू टू और टू या तो सेम स्पेलिंग होगी या फिर सेम प्रोनाउंसिएशन होगी. तो इसमें देखिए सेम प्रोनाउंसिएशन है तो इसको क्या बोलते हैं? होमोनिम्स. नेक्स्ट इज 3. सिलेक्ट द अप्रोप्रिएट आर्टिकल टू बी फिल्ड इन द ब्लैंक्स इन द गिवन सेंटेंस. ही इज ASP, NSP, NSP. A is the answer. Next is 4. Identify the figure of speech that best defines the following sentence. The camel is the ship of the desert. It is a simile or metaphor, irony, sarcasm. It is a metaphor. B is the answer. Next is 5. Identify part of speech in which the word round has been used in the following sentence. The earth moves round the sun. It is an adverb. D is the answer. Next is 6. Identify a type of sentence given below. John proposed that we should sing together. This is an optative sentence. What is optative sentence? Which expresses a wish or request. अब जॉन प्रपोज किया ना जॉन ने कि भाई हमें एक साथ गाना गाना चाहिए, तो ये उसकी इच्छा है. तो जो इच्छा जाहिर करे वो क्या बोलते हैं उसको? ऑप्टेटिव सेंटेंस. असर्टिव क्या होता है? विच स्टेट्स अ फैक्ट, एक फैक्ट बता दिया. फॉर एग्जाम्पल सन राइजेज इन द ईस्ट, सेट्स इन द वेस्ट, है ना. एक्सक्लेमेटरी को पता ही होगा, इसमें एक्सक्लेमेशन मार्क होगा. इज इट बोलते हैं ना आश्चर्य से, होता है एक्सक्लेमेटरी. फिर इम्पेरेटिव क्या होता है? विच डायरेक्ट्स कमांड. फॉर एग्जाम्पल शट द डोर, टर्न ऑफ द लाइट. दीज आर इम्पेरेटिव सेंटेंसेस. Next is 7. Which underlined part of the given sentence contains an error? So, if I was you, I would not agree to that foolish proposal. इसमें गलत कौन सा हुआ? इसमें A. If I were you. A is the answer. Next is 8. Fill in the blanks with the appropriate preposition. I cannot come back dash a month, before a month, in, within. I cannot come back in a month. B is the answer. Next is 9. Give one word for the following groups of word. A person aged between 60 to 70 is called as sexagenarian. A is the answer. Now there is a mistake here. 60 से 69 होना चाहिए, 70 नहीं होना चाहिए. 70 to 79 is septuagenarian. And quingenarian mean कौन सी एज होती है? 50 to 59 की एज। नैनोजेनेरियन 90 to 99 की एज। सेंट्राजेनेरियन दैट इज 100 to 109। सुपर सेंट्राजेनेरियन दैट इज 110 above। अभी now where it starts with denarian that is 10 to 19, then Vicenarian 20 to 29, Tricenarian 30 to 39, Quadranarian that is 40 to 49. Next is 10. Which one from amongst the choices given would mean the same as following sentence? I feel an aching void means void का मतलब क्या होता है? खालीपन, जहाँ कुछ भी नहीं है। तो क्या हुआ मतलब? I feel lonely. A is the answer. Next is 11. जीके के क्वेश्चन आ गई है। Recently which Indian cricketer has set a record by scoring the highest run in Test cricket? तो देखिए उस टाइम पर रिसेंट में था 2008 का पेपर है, तो उस टाइम सचिन तेंदुलकर ने जो है हाईएस्ट रन स्कोर किए थे, तो बी वाज द आंसर। नेक्स्ट इज 12. इन द लास्ट ओलंपिक बीजिंग हु वॉन फर्स्ट एवर इंडिविजुअल गोल्ड मेडल फॉर इंडिया? दैट वाज अभिनव बिंद्रा। शूटिंग में जीता था ना उन्होंने, तो बी वाज द आंसर। नेक्स्ट 13. टिल डेट हु इज द ओनली इंडियन टू हैव अवार्डेड द नोबेल प्राइज फॉर लिटरेचर? Rabindranath Tagore. C is the answer. Next 14. Which state of India has bagged 2 national award associated with tourism in 2008? So recent की जो अगर कुछ ऐसा मिला है तो वो देख लीजिएगा। उस टाइम पर केरला था। Next 15. What is the full name of President of India? At that time she was Pratibha Devi Singh Patil. B is the answer. Who is at present? Draupadi Murmu, है ना। नेक्स्ट 16. हु propounded the theory that अर्थ मूव्स अराउंड द सन? देखिए बहुत सारे लोग बोलते हैं गैलीलियो, बट नो, इट वाज कोपरनिकस। सी इज द आंसर। नेक्स्ट 17. जीरेंटोलॉजी इज अ ब्रांच ऑफ स्टडी रिलेटेड टू डिजीज एसोसिएटेड विद ओल्ड एज। सी इज द आंसर। चिल्ड्रन वाली कौन सी होती है? पीडियाट्रिक, है ना। वुमेन वाली गायनोकोलॉजिस्ट। This is 18. What is the title of the former US President Bill Clinton's autobiography? It was My Life. B is the answer. Next 19. On which date of the year World Environment Day is celebrated? It is June 5. C is the answer. Next 20. Who was the first Indian Prime Minister to address the UN General Assembly in Hindi? देखिए बहुत सारे लोग सोचते हैं कि वो अटल बिहारी वाजपेयी थे, नहीं, पहले थे लाल बहादुर शास्त्री। सी इज द आंसर। अब ये लॉ का पार्ट स्टार्ट हो गया यहाँ से 80 क्वेश्चंस। क्वेश्चन नंबर 21 इज फ्रॉम सीपीसी। ए प्लेंट इज लायबल टू बी रिटर्न्ड व्हेन रिटर्न ऑफ प्लेंट प्रोविजन किधर है? ऑर्डर 7 रूल 10। प्लेंट इज ऑन एन इनसफिशिएंटली स्टैम्प्ड पेपर, तो रिटर्न कर देंगे। नो। प्लेंट इज नॉट फाइल इन डुप्लीकेट, नो। अंडर वैल्यूड इन प्लेंट, इस पे क्या होता है? रिजेक्ट होता है। प्लेंट इज फाइल इन अ कोर्ट हैविंग नो जुरिसडिक्शन, यहाँ पर रिटर्न हो जाएगा। रिजेक्शन ऑफ प्लेंट के लिए प्रोविजन कहाँ है? ऑर्डर 7 रूल 11, तो इसमें डी आंसर रहेगा। नेक्स्ट 22. द एक्सप्रेशन ईच पार्टी शैल बियर हिज ओन कोस्ट implies that both parties are entitled to cost from each other, no, are not be deprived of cost, या फिर are to be deprived of cost, to be deprived of cost. C is the answer. No one shall have to give any cost. C is the answer. Next 23. Which of the following question is not to be determined by an executing court? Discharge of decree, yes. Execution, yes. Modification, no. Satisfaction, yes. So C is the answer. And where it is mentioned in section 47 of CPC. Executing court cannot modify the decree. Next 24. In which of the following cases Supreme Court has upheld the validity of section 51 of CPC? Which case was it? It was Jolly George Varghese versus Bank of Cochin. D is the answer. Next 25. In which of the following cases Supreme Court has upheld the constitutionality of the CPC Amendment Acts of 1999 and 2002? It was Slam Advocate Bar Association Tamil Nadu versus Union of India. A is the answer. It's a very common question. Next 26. Which one of the following is a true statement in relation to section 80 CPC? A suit without serving a notice can be instituted generally leave of the court. With the leave of the court. Or a suit without serving notice can be instituted in case of urgent or immediate relief with the leave of the court. This is correct. If in case of urgent or immediate relief, where leave to institute the suit without serving notice has been granted, interim or otherwise ex parte relief can be granted. This is also correct. No suit under section 80 can be instituted without the compliance of requirement of notice. No, urgent relief में कर सकते हैं. And this one C, in case of urgent or immediate relief, जहाँ पर लीव दे दी गई है अर्जेंट केस में विदाउट सर्विंग द नोटिस हैज बीन ग्रांटेड, ठीक है ना, तो वहां पर क्या इंटरिम और एक्सपार्टे रिलीफ नहीं दे सकते? वहां पर दे सकते हैं, बिल्कुल दे सकते हैं. दोनों ही ठीक हो गए इसमें. ये क्वेश्चन ये मैं कहूँगा ठीक नहीं, ऑप्शंस ठीक नहीं बनाए, दोनों ठीक हैं. ये प्रोविजन कहाँ है इसका? 80 सबसेक्शन 2. नेक्स्ट 27. अब मैच करना है लिस्ट 1 लिस्ट 2 को. सेट ऑफ क्या होता है? एडजस्टमेंट ऑफ डिफेंडेंट्स क्लेम विद द प्लेंटिव्स क्लेम. ये बिल्कुल ठीक है. ये प्रोविजन कहाँ है? ऑर्डर 8 रूल 6. मीन प्रॉफिट डेफिनेशन 212 में है. क्या होता है? गेन्स फ्रॉम प्रॉपर्टी बाय पर्सन हैविंग रॉन्गफुल पोजेशन. इंडिजेंट पर्सन कौन होता है? हु अलाउड टू फाइल सूट और अपील विदाउट कोर्ट फीस. प्रोविजन कहाँ है इसका? ऑर्डर 33. Subsistence allowance amount paid by decree holder for detention of judgment debtor in civil prison. इसका 1 रहेगा. प्रोविजन कहाँ है इसका? Subsistence allowance का प्रोविजन कहाँ पर है? सेक्शन 57 CPC. तो क्या बन गया इसका? 3421. तो ये रहा 3421. B is the answer. Next 28. Which one of the following pairs are correctly matched? Right to file caveat 148A बिल्कुल ठीक है. Pauper suit. It is order 33, not section 33. This is wrong. Privileged documents is nowhere mentioned. Section 29 is service of foreign summons. Powers of appellate court, it is 107. So this is also wrong. So only 1 is correct. A is the answer. 1 only. Next 29. फिर से मैच करना है लिस्ट को. Restitution afresh. It is setting aside ex parte decree and rehearing the case. Next friend, who is next friend? Representative of a minor or a plaintiff of unsound mind in civil suit. Legal representative, person representing the estate of deceased. Garnishes, debtor or judgment debtor liable for payment or delivery. तो क्या बन गया इसका? 4123. तो ये रहा 4123. B is the answer. Next 30. In execution of a decree for the maintenance, salary of a person can be attached to the extent of 2/3. C is the answer. This is a repeat question, है ना? Section 60 mentions what cannot be attached. In decree for maintenance, 1/3 cannot be attached. So 2/3 can be attached. Next 31. Order 18 Rule 41 of CPC. The examination in chief of witness shall be recorded by the judge or commissioner appointed by the court on affidavit. Now see, if you see this question in one way, these all are correct. How? Sub rule 2 mentions by the judge, by the court or commissioner appointed by the court, है ना? But they are particularly asking about the 4-1. So it shall be on affidavit. This is mentioned in 4-1. So C is the answer. Next 32. When a party is called upon by notice to admit facts by the other party under order 12 rule for CPC, the party on whom the notice has been served has to admit the facts within 9 days service of notice. B is the answer. And in the same rule, it has been mentioned that if refusal or neglect to admit the same within 6 days after the service of such notice, then there shall be cost on the party refusing. All right. 34. Where decree is passed against the Union of India or state for the acts done in official capacity of the officer concerned under section 82 CPC, the execution shall not be issued on such decree unless the decree remains unsatisfied for a period of 3 months from date of decree. A is the answer. It is mentioned in section 82 itself. 35. Adarshan, the rule of constructive res judicata is applicable to writ petitions. Yeah, it is correct. The reason is public policy consideration underlying res judicata also hold true in relation to writ proceedings. Yes, except habeas corpus. RJ is not applicable on habeas corpus. All right, but these are true. So A is the answer. Both A and R are true. R is the correct explanation of A. A is the answer. Next 36. A residing in Delhi publishes in Kolkata statement defamatory to B. B may sue A in Delhi or Kolkata. Either. C is the answer. This is illustration B in section 19 CPC. Next 37. Which one of the following suit is not of a civil nature? Suit relating to right to property. It is rent, yes. For recovery of voluntary payments or offering, no. Dismissal from service, yes. So voluntary payments, and then you are filing suit for recovery, no. It is not applicable. So C is the answer. Section 9 provides for suits of civil nature. Next 38. Which of the following is not a sufficient cause for granting adjournment? Sickness of a party, his witness or his counsel. It can be ground. Non-examination of witness present in the court. It is not. Non-service of summons. It can be reasonable time situation area. So B is the answer. Next 39. Where a plaintiff sues upon a document in his power or possession, he must produce it or a copy thereof along with the plaint. A is the answer. Next is 40. Voluntary amendment is provided for under order 6 rule 17. C is the answer. Next 41. There shall be no appeal by a convicted person where a CJM imposes only a sentence of fine not exceeding 100 rupees. C is the answer. And where this is provided, regarding this, it is provided in section 376, but there is no mention for CJM. However, JMFC, so it falls under the category of same method of first class, so not exceeding 100 rupees. Next 42. Too many appeals or revision are bane to the Indian judicial system, involving as it does sterile expense and delay and fruitless chase of perfection. Justice Krishna Iyer made this observation in Sitaram versus State of UP. C is the answer. Next 43. In the case of Supreme Court observed, thus, we are unable to find any magic or charm in the ritual of a charge. It is substance of these provisions that count or not their out form. To hold otherwise is only to provide avenues or escape for the guilt and afford no protection to the innocent. The court made these observations in relation to alteration of charge. A is the answer. Where is the provision for alteration of charge? 216 CRPC. Next 44. Which of the following offences triable summarily? Summary trial chapter is 21 and from section 262 to 65. Which offence came in trial summarily? It is mentioned in section 260 itself. Next 45. The period of limitation prescribed for taking cognizance of the offence punishable with imprisonment up to 3 years is 3 years. Section 468 provides for the same about limitation for taking cognizance. If it is fine only offence, then it is 6 months. Imprisonment is up to 1 year, then it is 1 year, and it is from 1 to 3 years, then 3 years, and above 3 years, no limitation. Next 46. In which of the following cases the constitutional validity of section 433A CRPC was upheld? It was Ashok Kumar Golu versus Union of India. A is the answer. Next 47. Which of the following is an interlocutory order for the purpose of revisional powers of High Court or Session Court? Order summoning witnesses, या फिर order of bail granted by magistrate, order rejecting the plea of the accused on the point which when accepted will conclude the particular proceeding, या फिर interlocutory order which are without jurisdiction and nullities. This is the one. D is the answer. Next 48. A is only charged with theft and it appears that he committed the offence of criminal breach of trust. In this context, which one of the following is correct? He may be acquitted, he may be convicted for theft only, or he may be convicted of criminal breach of trust. This is correct. C is the answer. And This is illustration B to section 221, where it is for doubtful charge. Next 49. Which of the following court can set aside or modify the condition imposed by magistrate when granting bail? High Court of Court of Session under section 439 CRPC. It is correct. High Court under 482. No. Provision is mentioned in section 439. So A is the answer. Next 50. An offence of bigamy punishable under section 494 was committed by A in Patna. The place where A resided with his first wife B was Gaya, and the place where his first wife took up a permanent residence after the commission of the offence is Bhagalpur. The offence may be inquired into or tried by a court of competent jurisdiction at Patna, Bhagalpur, Gaya, if all of the above. All of the above, D is the answer. Section 51. A magistrate has power to deal with urgent cases of apprehended danger or nuisance under section 144 CRPC. B is the answer. Next 52. Which of the following magistrate have power to prohibit repetition or continuance of public nuisance? DM, SDM, judicial magistrate, executive magistrate duly empowered in this behalf. ये executive magistrates की power होती हैं, तो 124 C is the answer. And this is mentioned in section 143 CRPC. Next 53. Assertion. The provision for reviewing the decision of a criminal court are essential for the due protection of life and liberty. This is correct. They are based on the notion that judges and magistrates are not infallible. This is also correct. So both are correct. A is the answer. Next 54. Assertion. Subject to some exception, the provision of the CRPC are not applicable to tribal areas in undivided Assam. This is correct. These areas enjoy special status like state of Jammu Kashmir. No, it is not correct. So A is correct, R is false. C is the answer. Next 55. Reason for non-applicability of some of the provisions of CRPC to the state of Nagaland have been stated by the Supreme Court in State of Nagaland versus Chung. D is the answer. Next 56. Who can appoint a police officer as assistant PP for the courts of magistrate? Next 57. Whom the following can be arrested without warrant by any magistrate? Any person committing offence within the local jurisdiction of such magistrate but not in his presence. No. Person committing offence anywhere but in his presence. No. Any person within local jurisdiction of whose arrest he is competent to issue a warrant. Yes, it is correct. C is the answer. Arrest by magistrate is mentioned where? Section 44 CRPC. Next 58. Now list 1 list 2 को match करना है. So special metropolitan magistrate is empowered to imprisonment up to 3 years. Yes. Chief metropolitan magistrate 7 years. Judicial magistrate second class 1 year. Assistant session judge, it is in up to 10 years and fine. So 3142. So this is 3142. D is the answer. This is section 2829 of CRPC. Next 59. Where 2 or more courts have taken cognizance on the same offence and a question arises as to which of them ought to inquire into or try the offence, the question shall be decided by, if the courts are subordinate to the same high court, then by that high court. It is correct. By the high court within local limits whose appellate criminal jurisdiction the accused resides. No. If the courts are subordinate to same high court, by that high court in consultation with the state government. No. If the courts are not subordinate to the same high court, by that court within the local limits whose appellate criminal jurisdiction the proceedings were first commenced. It is correct. So 1 and 4 are correct. C is the answer, and this is section 186 CRPC. Next 60. Assertion is power of the state to order cases to be tried in different session division is very limited. This is correct. Reason is that this extraordinary power is to be used when consideration of public justice justifies its exercise. This is also correct. And correct explanation, A is the answer. Next 61. Husband and wife are competent witnesses against each other in matrimonial cases or in one person in law या फिर in civil cases, civil as well as criminal cases. D is the answer. Next 62. Now list 1 list 2 को मैच करना है फिर से. ब्लड स्टेन्स एंड ब्लड ग्रुप, इस एविडेंस के बारे में कौन से केस में बात की गई है? स्टेट ऑफ गुजरात वर्सेस छोटेलाल पटनी, ऑटोमेटिक कैमरा, बी वर्सेस अटॉर्नी जनरल, टेप रिकॉर्डेड स्टेटमेंट, रैग वर्सेस डॉडसन, हैंड राइटिंग यूसुफ अली स्टेट ऑफ महाराष्ट्र. क्या बन गया? 2 3 1 4. सी इज द आंसर. Next 63. Which of the following pair is not correctly matched? That a man heard or said something. It is a fact. It is correct. Map or plan is a document. Yes. Copies made from or compared with the original. It is an evidence. It is secondary evidence. Facts connected to a fact in issue in such a manner as to constitute part of same transaction. It is just not rule nisi. So this is incorrect. Not correctly matched. D is the answer. Next 64. Again list 1 list 2 को मैच करना है. कन्फेशन कोज्ड बाय इंड्यूसमेंट, थ्रेट और प्रॉमिस, मैं इसको बोलता हूँ PIT, पीट दिया उसको. सेक्शन 24 में लिखा हुआ है ये. तो कौन सा केस है इस पर? पैरेलल भार्गव वर्सेस स्टेट ऑफ राजस्थान. कन्फेशन टू कस्टम ऑफिसर, स्टेट ऑफ पंजाब वर्सेस बरकत राम. कन्फेशन इन द FIR गिवन बाय द एक्यूज्ड, अग्नु नागेशिया वर्सेस स्टेट. डिस्कवरी ऑफ फैक्ट परसुएंट टू स्टेटमेंट इन पुलिस कस्टडी, स्टेट ऑफ बॉम्बे वर्सेस काटिकालू ओगड़. क्या बन गया इसका? 3 2 1 4. ये रहा 3 2 1 4. डी इज द आंसर. Next 65. Question is whether A was robbed. The fact that he said he has been robbed without making any complaint is not relevant, but may be relevant under section 32 157. D is the answer. And this is provided where? This is illustration K to section 8 of Evidence Act. Next 66. A is accused of receiving stolen goods while knowing them to be stolen. He offers to prove that he refused to sell them below their value. He may not prove the statement या फिर if it is relevant, otherwise an admission या फिर as it is explanatory of conduct influenced by the fact and issue. C is the answer. And this is illustration E to section 9 of Evidence Act. Next is 67. An admission by guardian ad litem against a minor is an evidence. No, it is not correct. Admission on point of law made by a pleader in court or behalf of client is admission. No. Admission by one or several defendant in a suit against defendant is evidence. No. Admission of fact made by pleader in court on behalf of his evidence. This is correct. This is an admission. D is the answer. Next 68. Which one of the following is the true statement in relation to relevancy of character? In criminal cases, previous good character is irrelevant. No, it is relevant. Previous bad character is relevant. No. Evidence of good character is given. In civil cases, character to prove conduct impeded is irrelevant. This is also incorrect. In civil cases, character of any person affecting the amount of damages is relevant. This is correct. D is the answer. This is section 53. This is 54. This is 52. This is 55 in Evidence Act. Next 69. When the court has to form an opinion as to digital signature of any person, the opinion of which the following is relevant: certifying authority or control appointed under the IT Act या फिर internet service provider या फिर certifying authority which had issued a digital signature certificate. D is the answer. This is a repeat question. This is section 47A, and now this digital has been amended by the Amendment Act of 2009 as electronic signature certificate. This is a question paper of 2008, so amendment came later on. Next 70. Which of the following cases Supreme Court raised doubt regarding the applicability of doctrine of equitable estoppel beyond section 115 Evidence Act? It was Madanappa versus Chandramma. B is the answer. Next 71. No revenue officer shall be compelled to say whence he got any information as to the commission of any offence against public revenue. It's section 125. A is the answer. Next 72. No confession made to a police officer shall be proved as against a person accused of any offense. The rationale of this rule is stated in Queen Empress versus Babulal. So B is the answer. Next 73. Where a bill of exchange is drawn in a set of 5, how many of them need to be proved? 1 only. C is the answer. And where it is mentioned in section 39 of Evidence Act. Not as illustration, but the relevant provision is 39. Next 74 assertion is A gives B a receipt of money paid by B. Oral evidence is offered for the payment. The evidence is admissible. Reason: a receipt is not a contract or grant in respect of oral evidence is barred. So this is correct, and this is illustration E in section 91. And the receipt is not a grant or in respect of oral evidence of which oral evidence is barred. So these both are true, and correct explanation A is the answer. Next 75 assertion is section 91-92 Evidence Act should be read together. It is correct. These two sections supplements each other. Yes, it is correct. So both are correct. A is the answer. Next 76. The court shall take judicial notice of foreign judicial record, no. National flag of state not recognized by India, no. Stephen Digest of criminal, no. Rule of road on land and in sea, it is correct. D is the answer. The provision is in section 57-58 of Evidence Act. Next 77. Which of the following is an example of may presume? Presumption as to electronic record or digital signature certificate or electronic message or agreement. As to electronic message, it is in section 88A. C is the answer. Presumption as to electronic agreement is provided in section 85A, and digital signature certificate is now changed to electronic signature certificate, and this is 85C. Next 78. Section 58 of Evidence Act deals with formal admissions, evidentiary admissions, formal as well as evidentiary admissions, proof of facts by oral evidence. Formal admissions, A is the answer. Next 79. Which of the following pair is not correctly matched? Relevancy of a statement as to law contained in law books, section 38 Evidence Act. It is correct. Relevancy of maps, charts. This is 36, not 35. Relevancy of certain evidence for proving subsequent proceeding the truth of fact therein stated. It is 33. Relevancy of statement as to the facts of public nature. It is 37. So two are incorrect here, B and C. Next is 80. In which of the following instances there is no reason ground for asking the witness the question whether he is dacoit? A barrister is instructed by an attorney that important witness is a dacoit. This is a reasonable ground mentioned as illustration A in section 149. Pleader informed by a person in court that important witness is a dacoit. The informant, on being questioned by the pleader, gives satisfactory reason for this statement. This is a reasonable ground. See, a witness of whom nothing whatsoever is known is asked randomly whether he is a dacoit. It is not a reasonable ground. This is illustration C. This is illustration B in section 149 Evidence Act. If it has a witness of whom nothing whatsoever is known, being questioned as to his mode of life and means of living, giving satisfactory answers, this is a reasonable ground. So what is not a reasonable ground? C is the answer. This is illustration D. Next 81. The principle of agency of necessity is applicable in emergent situation where communication with the principal is not possible. It is correct. Applicable in normal situation if the communication with the principal is possible. No. Unknown to the law of agency. No. A is the answer. Next 82. A gives woolen cloth to B, a tailor, for making a suit. A tailor's charges are settled at rupees 500. The suit is ready. A tenders 500 to the charges, but the tailor refuses to deliver the suit till A pays all dues. In such case, B cannot refuse to deliver the suit. B is the answer. अगर ओल्ड ड्यूज है तो उसके लिए अलग से केस करना पड़ेगा, बट इसके लिए मना नहीं कर सकते। बी इसका आंसर रहेगा। नेक्स्ट 83, विच ऑफ द फॉलोइंग इज करेक्ट। नेक्स्ट 84, the liability of the surety is coextensive with that of principal debtor unless it is otherwise provided by the contract. Is correct, totally correct. Now reason is, any variance made without the surety is concerned in the terms of contract between the principal debtor and the creditor discharges the surety as to transaction subsequent to variance. It is correct. So both are correct. इसका आंसर रहेगा A. Both are correct, but it is not the correct explanation of A. क्या इसका रीजन हो सकता है? दिस इज अ फैक्ट, इसका रीजन नहीं है, तो बी इसका आंसर रहेगा। ये भी एक फैक्ट है, ये भी एक फैक्ट है, बट क्या जो रीजन होना चाहिए वो रीजन नहीं है। Additionally, section 128 and the reason this is section 133. So both are particular provisions. Next is 85. A, without the request of anybody, extinguishes the fire of godown. A suffers injury thereby. B promises to compensate A for the whole amount he has spent for his treatment. The contract is enforceable. D is the answer. It will fall under exception 2 to section 25 of Contract Act. Next 86. Promissory estoppel is sometimes spoken as a substitute for. Next 87. X, a trader, leaves good at Y's house by mistake. If Y uses the goods, then which one of the following is correct when X demands the price for the goods and Y refuses to pay? Y is not bound to pay as he become the owner of the good left at his home. Wrong. Y is bound to pay as X did not intend to supply the good gratuitously and Y enjoyed the benefit of X's act. This is correct. And this is illustration A to section 70 of Contract Act. This is section 70. X is not bound to pay. Wrong. So B is the answer. Next 88. X contracted with a tent house for erecting a shamiana for performing the marriage of his daughter. On the day of marriage, a curfew was clamped in the area preventing the celebration of the marriage. The shamiana owner claims the charges agreed to paid by X. In the light of the above, which of the following is correct? X has to pay the contracted damages. No. Need not to pay that, but only reasonable charges. No. X can require state to bear the claim, या फिर X need not to pay anything as celebration of the marriage was impossible on the count of curfew. D is the answer. Doctrine of impossibility would be applicable as per section 56 Contract Act. So D is the answer. You can take also the example of Krell versus Henry. Next 89. In which of the following instances has the discharge of agreement not been affected? A promises to paint a picture for B. B afterward forbid him to do so. It is discharge. A owes B rupees 5,000. C pays to B rupees 1,000, which B accepts in satisfaction of his claim against A. It is correct. A awaits arrival or B to finish the painting for B. There is no discharge because he is waiting, है ना? A owes B rupees 2,000 and is also indebted to the other creditors. A makes an arrangement with his creditor, including B, to pay them half of the loan amount. A pays B rupees 1,000. This is correct. So C is the answer in this case. No discharge. No discharge of agreement has been effected. Next is 90. A contingent contract based on specified uncertain event not happening within a fixed time. Okay, this is section 35, part 2. Can be enforced if the event does not happen within the fixed time. Cannot be enforced at all. Wrong. Can be before the expiry of fixed time. It becomes certain that such event shall not happen. It is correct. Either you get the information before expiry or till that time fixed for performance. So both are correct. A and C. D is the answer. Next 91. Which one of the following is a contract? Agreement to do lawful act by unlawful means. It is not a contract. An undertaking in writing duly signed to pay a time bar debt. This is a contract. It is exception 3 to section 25 Contract Act. An agreement restraint of lawful trade. It is void as per section 27 Contract Act. A agreement to pay rupees 10,000 without consideration. It is void. This is illustration A to section 25. So B is contract B is the answer. Next is 92. Which one of the following is not provided in section 4 and 5 of the Contract Act? Communication of offer, communication of acceptance is there. Revocation of proposal and acceptance is there. Revocation of contract, no, it is not there. So D is the answer. Next is 93. Which one of the following does not amount to fraud? Active concealment of a fact, it is a fraud. It amounts to fraud. Promise made without intention of performing it, it amounts to fraud. Suggesting as a fact of that which is not true by one who does not believe it to be true. This is correct. A representation made without knowing to be false, honestly believing it to be true. This is not fraud, so D is the answer. Section 17 of Contract Act talks about fraud. Next, 94. A stipulation for increased interest from the date of default is known as penalty. B is the answer. Next, 95. Now you have to match the list. Tin versus Hoffman, it is on cross offer. Fisher versus Bell, invitation to treat. This is a repeat question actually. Carl versus Carbolic Smoke Ball Company, offer at large. Hare versus Facey, quotation of price. So क्या बन गया इसका? 3124. So this question was actually deleted because the options were not proper. Option इसमें थे ही नहीं. 3124 बनाई नहीं कहीं पर भी. Next, 96. Which one of the following proposition is correct? A minor's agreement being void, a minor is not bound to pay for necessities supplied to him. No, wrong. Minor's contract being voidable, he is bound to pay. Wrong. Minor is bound to pay for necessities supplied to him because a minor's contract is valid. No. A minor's contract is void, but he is bound to pay for necessities supplied to him. It is correct. As per section 68. So D is the answer. Next, 97. Again, matched करनी list को. Supervening impossibility is called frustration. Consideration is quid pro quo. Good faith, it means utmost faith. Ubrima fides contract. What is the meaning of ubrima fides? Utmost faith. Dunlop tire and self regis को किस पर है? ये privity of contract पर है केस. तो क्या बन गया? 2413. 2413 is there. C is the answer. Next is 98. Assertion is brokerage contract is valid. It is correct. Reason is brokerage contract is opposed to public policy. No, it is not. So A is true or is false. C is the answer. Next, 99. Which of the following are duties of bailee? Duty to take reasonable care of goods. It is correct. It is provided in section 151 of Contract Act. Then duty not to make unauthorized use of goods. It is correct. Not to mix his own goods with goods bailed. It is correct. Duty to compensate when goods are damaged despite of the care of bailee. No, it is not. So 1, 2, 3 are correct. B is the answer. Next is 100. Adamson versus Jarvis is leading case on. It is on contract of indemnity. B is the answer. So friends, here we have discussed all the questions of preliminary exam paper of Jharkhand Judicial Services 2008. अगर आपको इसमें कोई कमी लगी हो, कोई सजेशन हो, कोई एडवाइस हो, कोई कमेंट्स हो, तो आप जो है कमेंट सेक्शन में जाकर भी लिख सकते हैं. वी ऑलवेज अप्रिशिएट योर कमेंट्स. एंड अगर आपको ये वीडियो अच्छी लगी और एफर्ट्स हमारे अच्छे लगे हो तो इसको जरूर लाइक कीजिएगा, शेयर कीजिएगा अपने फ्रेंड्स के साथ, सो दैट दे कैन कम टू नो अबाउट आवर चैनल एंड वो भी बेनिफिट ले सकें. एंड अगर आपको हमारे एफर्ट्स अच्छे लगे हो तो इन एडिशन टू लाइक एंड सब्सक्राइब काइंडली गिव अस अ सुपर थैंक्स. सुपर थैंक्स इज अ वे टू अप्रिशिएट द कंटेंट क्रिएटर. आप जो है जो भी कंटेंट बनाता है उसको अप्रिशिएट करने के लिए कोई भी अमाउंट जो है डोनेट कर सकते हैं. फ्रॉम मिनिमम स्टार्ट्स विद 40 रुपीज़. तो काइंडली गिव अस अ सुपर थैंक्स. So friends, thanks very much for watching this video. Thank you.